Hello and welcome back to our YouTube channel. Well, it is our 13th lecture on Indian polity and it is 20th June 2025. So before we'll start our discussion, I would like to give some brief introduction about this initiative which we started from 2nd June, so that if you want to get connected with us, you will get connected with us, and you would watch these videos if you would like the initiative. Basically, the initiative which we had started from 2nd June is Target IAS 2026. Under this initiative, every day we are uploading two videos. First, in the morning session, where we discuss the daily news analysis. Here what we do, we take up the most important articles from the newspapers, we discuss them, we break them down into the simplest language possible, and we give the idea what is in the news, how it is important for your preparation, and how you can expect the possible prelims or mains questions from these articles. We give this by an example after every topic we discuss there. So this is what we do in the first video. In the second video, we discuss the static syllabus. And here we had started with Indian polity, as you can see here. And right now we are discussing the directive principles of state policy. So about this initiative, we are taking the full control of your syllabus here. We are taking both daily news analysis, the current affairs which you need to clear the exam, as well as the static part which is important for you to clear the exam, whether it would be related to prelims or mains. And one more thing we do here, as we are making these videos for you guys, at the same time we are making the notes for your preparation with respect to each subject, so that if we miss any point here, we will add that point in our notes, and as well as add everything what is required for you to clear the exam. We will take up every concept, every topic which is essential for you. We will explain those topics in those notes, and we will derive the questions from every topic after the discussion, so that it will give the full idea how questions are asked and how you should prepare and what is required for you. It would be all given under those notes which we are preparing for you. But to get the access of those notes, you would need to pay 200 rupees only per subject once we complete the syllabus of this subject. So this is about the initiative. If you like this, please do let us be the part of your journey. Do watch these videos. They are totally free. You are paying in thousands and lakhs in other coaching institutes for these videos, but we are providing you this information totally free. If you want to be the part, please be the part of this initiative, and let us help you where you need the help. So with this, let's start our discussion from where we left yesterday. Yesterday we completed the part 3 of the Indian Constitution, which is fundamental rights. We discussed them in a very detailed way. Almost it took us 5 to 6 lectures to complete the fundamental rights. We discussed every aspect of the fundamental right, in a very detailed way, so that if any question, after watching my video about the fundamental rights, after watching these videos, if any question would be asked with respect to the fundamental rights, or with respect to the citizenship which we discussed earlier, or with respect to the part 1 of the Constitution, union and its territories, or with respect to the preamble, or with respect in general with respect to the Constitution, the essence of the Constitution, if any question would be asked, you should be very much ready to answer that. Now from today we are going to discuss the directive principles of state policies. We are going to discuss directive principles of state policy. So what is this directive principle of state policy? We often have a misunderstanding over it. Are they rights? Are they duties? What are these? On who has to implement these directive principles? Are they enforceable? If it is violated, do we need to go to the court? So all these things we would cover here. We'll discuss them one by one. We'll see how they are differentiated, how they are divided into the Gandhian, where we see the Gandhian approach, we see the socialist approach, we see the liberal approach in the directive principles. We'll discuss them in a very detailed manner, and I guess this class will last a little longer today. So about directive principles, let me tell you what it is. I had started this initiative here. I'm teaching here. I'm giving the lectures. What is the reason for that? why I am teaching you here on my YouTube channel, why I am giving these lectures, why I am working so hard for these videos. What is the reason for that? You know, what is the reason for that? What is the reason I am giving these videos yet I am not even getting the views? You know, what is the reason for that? The major reason, which if I will be honest with you, if every educator will be honest with you, to get the views, to get the views. That's why I had started this YouTube channel, so that I can provide you the information which you will like, which would be helpful for you, but eventually it will help me how I will get the views, and I can generate the revenue. I can regenerate the revenue. So this is the whole purpose. This is the whole principle of this YouTube channel. If I will be very much honest with you, and if everybody, whether you are taking your classes from whichever institute, if you will be if they will be honest with you, the whole purpose of this is to get the views, to get the money from this, to get the revenue from this. And what is the purpose of the constitution? What is the purpose of the laws which are made by the laws which are made by the executive or legislature? What is the purpose of that? The purpose is this directive principle. This directive principle gives the lawmakers the purpose. If they are going to make any law, there should be the purpose, and this purpose is given in the directive principles. So what is this purpose? That we will understand one by one. Let us have a look at it. Let's have a look at the basic introduction. What is the nature and purpose of the directive principles? So first, about the directive principles, we have to know that, you know, they are non-justiciable. Justiciable. For example, we have a directive principle under Article 44 of the Indian Constitution, which says state should endeavor to have a uniform civil code. Uniform civil code. So what about it? Yet in our country, there is no uniform civil code, you know, with some exceptions from the Goa and Uttarakhand. Recently they enacted the uniform civil code. So can we go to the court? You know, for example, I am living in Delhi. I don't have a uniform civil code here. Can I go to the court? Sir, we have a directive principle which says that the state should endeavor to have a uniform civil code, but we don't have it. Please tell the state to give me this directive principle. You know what court will say you? Court will say you that, have you not read the directive principles? You will say, yes sir, we had read it. There is Article 37. Article 37 says that it is not enforceable. You know, you cannot go to the court and tell them, please enforce this on us. It is not enforceable. Like we have the fundamental rights, where the fundamental rights are enforceable. And one more thing here I would like to mention that about directive principles is that these directive principles, they are the positive obligations of the state. Here in fundamental rights, we saw that how they are the negative obligations. In fundamental rights, we say that state, please don't interfere. I have the freedom of speech. Please don't interfere. I have the freedom to live with liberty. Please don't interfere. And sometimes we say, state, please interfere. I want to get the education. How Amendment for 21A was introduced. So majorly, if we will see the fundamental rights, they are the they have the negative obligation on the state. They put the negative obligation on the state, but the directive principles, they have the positive obligation on the state. State has to do it. State should do it. State should endeavor to bring in the uniform civil code. You know, this is the basic principle of this is the basic purpose of the directive principles. You know, state is going to make laws, and they have to look into it whether it stands the directive principles of the state policy. So it is like a timetable, as Nehru said about directive principles, that directive principles will act as a timetable. In our lame language, if we will say, act as a timetable. For example, you are preparing for UPSC right now, and you would have a timetable for that. For example, on Mondays I will discuss Indian polity. I will study Indian polity. Then I will for 2 hours I will study CSAT. After that, I will go through the news analysis. Then I will go through the magazines. Then I will take the revision. Something like that. Whatever timetable you would have made And one more thing, one good thing about timetables, about the people who often make timetable, they don't study that, they don't follow that. That is something some different thing. But here, what is this directive principles? It is a timetable to the governance. It is a timetable to the government. They will look at what we had brought till now. Had we brought the uniform civil code? Is there equal wages for equal work? Yes, they had done it. Are we protecting the monuments? Yes, we are protecting. We had enacted the laws. Is there panchayati raj system? Yes, we had done it. So this is like a direct. It would act as a timetable for them, and they will take it that we had done it, we had achieved it. So this is what this acts as a fundamental. It is not enforceable, but it is fundamental to governance. The directive principles, they are not enforceable, but they are fundamental to governance. This is what directive principles are. They are not non-justiciable. We understood it. Fundamental in governance, they have to look after it, whether whatever features are given in, whenever they are going to make any law, whether they follow the principle of directive principles, whether the gist of directive principles is mentioned in those laws. And then the major aim of it is for a welfare state. The government is supposed to interfere to bring in the welfare state. For example, I will give you an example here. Suppose there used to be the zamindari system, and this this land, it was given to them by the British officials. Huge parcels of the land were given to them by the British officials for being loyal to them. Maybe during 1857 they supported them. So in giving for the reward sake, they gave them these lands, or for the maintenance sake, for we have Mahalwari system, we have different tax system during the British era, which we will discuss in the history. For that sake, they gave this land parcel to them. Now this land was there, it was there till we got independence, and it was still there after we got the independence. Now what used to happen, these zamindars, they were not able to to manage or to get the fruits from this land by themselves. What they will do, they will appoint small peasants who will work in their land, and they will cultivate the land, and most of its profit will go to the zamindar, and the person who is cultivating it, for them they will get the daily wages. And for in some cases not even the daily wages, they will either work for the beggar, which we discussed when we discussed about the exploitation. So this was the case in India at that time. What government decided that, look at the picture, the zamindars, they are getting richer by the time, and these peasants, these small peasants, they are getting even poor, because their family is growing. They are there was no control, no birth controls were there. Family was growing exponentially, and they were getting more poor. And this zamindari system, the zamindars, they were getting more rich, because they had more people to cultivate, and they used to get more profit out of it. So what state will do? State has the duty, fundamental duty, or we can say has a directive principle that aim for a welfare state. What state will do? It will take some land from them, and it will distribute it with the peasants, and it will make peasants that you are the owners of this land now. Now you cultivate for yourself, and you will get the benefit of it, and state can do it. So the whole principle of this is to have a welfare state. Similarly, you would have seen in elections, there are various elections going on, whether it would be the parliament elections or the state legislature elections, or in UTs we had seen, especially in Delhi, we had seen recently elections. And what was the manifesto of the elections? What was the major manifesto of elections? That if you vote for us, we will give you 5,000 rupees per every woman. For every pregnant woman, we will give you 5,000 rupees. We will give you 6,000 rupees. Different political parties had different intentions. And if we will take the example of the Tamil Nadu, their political parties, what they decided, that if you vote for us, we will give you the color TVs. We'll give you color TVs. So this case, it went to the court, and said a person, he went to the court, sir, it is the corrupt practice which the political parties are doing right now. What they are bribing the voters, what they are doing, they are bribing the voters to vote in their favor, so that they will give them the color TVs. So please ask them, please stop this, otherwise this whole, you know, whole concept of democracy in our country will get diluted, because the more powerful, the more richer the political party would be, the more voters they will gain through it, because they will have more money to spend. What Supreme Court did, what courts did, they asked the political party, they called the political party and told them why you are doing this, what is the reason for that, why are you giving these freebies to them. You know what they said, sir, and the name of this person who filed this PIL was Subramaniam Balaji in Subramaniam Balaji in 2013. So courts asked him, asked the political parties, why you are doing this? You know, what is the purpose of that? You know what political parties said? Sir, look at the constitution, look at the DPSPs. You know, our aim is to go for the welfare state. The court said, how by giving the color TV is it you are working on the welfare of the people? They said, sir, look, it is a very deep concept. You have to understand it. These women, women work whole day, you know, full day they work in their house. You know, they have to wake up early in the morning, they have to cook, then take care of the children, then wash the clothes, wash the dishes, you know, till morning till evening. From the morning till evening they are working, and after work, if they want to relax, they would want to have some enjoyment in their life. So if we are granting them TV, what is wrong with that? If we are giving them color TV, what is wrong with them? And also they mentioned that in this color TV, in this they are not going to watch only the serials, they are not going to watch movies, you know, they are also going to watch the news in it. They will also watch about what is how the political parties are working. They will also watch what is the manifesto of different political parties. And these political parties said that we are, you know, in a way we are encouraging them, we are encouraging these women to have a better understanding of the politics, so that we can empower them, so that they can take their decisions on their will. You know, earlier what used to happen, even still it is going on, that a woman will vote only to that candidate to which his or her husband will to which her husband will vote, or her parents will vote. So they don't have an independent choice. If we will give them the television, they will have this independent choice, they will be more, you know, they will have this independent choice, and they can vote in our way, in whatever way they want to. So we are in a way uplifting them, where it is for the welfare of these women, so that they will choose the political party of their will, and they will get the benefits what they want. So in this way the Supreme Court got shocked. They said that it is not our matter, it is not our concern, it is the election commission which will decide over it. In nutshell, what is the point of this? The point is that where from they get this power to give these freebies, they get it from where? They get it from the DPSPs, to endure, to aim for a welfare state, to aim for a welfare state, to aim for a welfare state. So if it was not there, then they could have not done it. Similarly, you know, as about welfare, we are discussing welfare right now, we are discussing the freebies. It would have been better if these freebies are given, and it would have been better if it was given to the targeted individuals, for those who need it. But in our country, in the states where it is more prevalent, the freebies are given to everybody, whether they need it or not, it is given to everyone. So this is some different discussion which we will discuss when we will take the social issues in our country. But here, what is the purpose of DPSPs? The purpose is to have a welfare state. The purpose is, you know, it should be the fundamental in the governance. It it will act as a timetable to the government, that they have to go for all these things. So this is in nutshell the small introduction about the fundamental rights. So I hope till now everything is very much clear to you guys, how it is enforceable, how it is not enforceable, how it is fundamental in nature, and what did the Nehru said, that it will act as a timetable to them, you know, what they had achieved, you know, the to-do list, it would act as a to-do list for them, what they had achieved so far and what they have to achieve after that. So this is what this preamble acts as. And also B.R. Ambedkar said that it referred DPSPs as an instrument of instructions resembling those enumerated in the Government of India Act 1935. It acts as an instrument of instructions. Now this is till now it is very much clear. Now let's start our discussion further. Let's move little further. If we when we will read these the DPSPs, they have very basic language, and there are few articles. For example, when we will discuss Article 39 AB, Article 39 B and C, A, B, and Article 39 A, B, and C. There we have to discuss a little bit more. Then also we left Article 30 because we did not discuss the Article 30 in fundamental rights, because there is definitely the connection, which we will discuss how they are inferior to fundamental rights and various judgments that we will discuss. But here let's move to our let's start what directive principles are. Let's start them. Let's try to understand them one by one. Then at the end we will give the further discussion about various articles which are very much relevant to be discussed separately. So let's have a look at it. This is the classification of DPSPs. It is classified into three. The socialistic principles, as we discussed, there are various principles if classified. This classification, first you should know that this classification is not given by the Constitution. It is given by the experts of the Constitution, that our DPSPs, they could be classified into three. What are these three groups? The first one is socialistic principles. In our DPSPs there are socialistic principles. When there are socialistic principles, it means that it would be talking about the welfare of the people. It would be more related to the workers. It would be more related to the to the welfare of the people. So these would be the features. Then it talks about the Gandhian principles. It would be related to the welfare of the lower castes, SCs and STs. It would be related to the panchayats, and there would be intermingling of the articles between the two, because we saw that how the socialism it basically started way back. But the understanding of the socialism, if we will try to understand it, it has the connection with the Marx. It has the connection with him, and we know that what is the communist for Karl Marx. What is a communist state for him is the Ram Rajya for Mahatma Gandhi. So definitely there would be the overlap of the articles between the socialistic principles and the Gandhian principles. Then the third classification is the liberal principles. So that we will understand one by one here. Now let's have a look at the socialistic principles. What are the articles? First we will look at the articles, then you will get the understanding about it. Let's have a look at the articles first, one by one. So here, Article 36, it gives a definition of the directive principles. What is the definition of the directive principles? It is same as what was under Article 12 of Part 3. It is same as what was under the Article 12 of the Part 3. What was the definition of state under Article 12 of Part 3? It was the Parliament or the Government of India, state legislature, or the or the state government, and then all local bodies within the territory of India or under the control of the government. So it is the same. The definition for the state will be the same, because in DPSPs we will see the state shall do it, the state shall secure this, the state shall endure it. So this state, what is this state? Whom we are asking this directive principle from? So this definition of the state is given under Article 36, which is same as Article 12 of the Indian Constitution. So this is Article 36. What does Article 37 say? Article 37 says, application of the principles contained in this part. The provisions contained in this part shall not be enforceable by any court. So the provisions are not enforceable under any court. You cannot go to the court, sir, the state has not brought the uniform civil code yet, because it is not enforceable. But the principles there inlaid are nevertheless fundamental in governance. They are fundamental. Principles are fundamental in governance. Whenever they are going to make any laws, they have to look into the directive principles. They should try to frame those laws in that way that the directive principles are contained in it. So this article 37, what does it say? It talks about the enforceability of the fundamental of the directive principles, that it is enforceable by the law, it is not enforceable in the court. Second, it would be fundamental in governance. So this is what article 37 says. Now article 38, it says state to secure a social order for the promotion of welfare of the people. That what we discussed, that the state has to promote the welfare of the people. They can change the nature of the property, because of which the article 30, which was the to have a property, if state wants to acquire the property, they have to give the compensation. It was removed from the fundamental rights because there were often commitments. This to secure a social order for the promotion of welfare of the people. Because of this article, political parties, they go for the freebies. There is revity culture in it, and the state has to do it. Now let's read the provisions one by one. It says that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. Then second, the state shall in particular strive to minimize the inequalities in income. State shall minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities. There should be, state shall endeavor to have the inequalities in income. For the same work, same salary should be given, whether you belong to any caste, any creed, any sex. If you are working the same, then the state should give you the same property. Now suppose here is a question. You are working for a film industry. Suppose you are making a movie. I'm making a movie and I hire Salman Khan as the hero and some lady who is unknown yet. She as an actress, she as a heroine in my movie. Once I will do the business, whom I will pay more? Definitely I will pay Salman Khan more. Definitely I will pay Salman Khan more. So can this woman go to the courts? Sir, I was working and I was working for a film, and my co-actor, he worked as much as I worked. Even I acted much better than him, but still I got less salary as compared to him, even though we have the acts with respect to it. But still I got less salary with respect to him. So can court sue me? Can she sue me in the court? No, she can sue me. She can't sue me. First reason, this fundamental duty, it is not enforceable. Second, I am a private person. I am a private person. I am a private person and I don't come under the definition of the state. When I don't come under the definition of the state, my focus is majorly on the profit. If Salman Khan is earning revenue for me, definitely I would give him more money as compared to the other actress who is working, who is unknown to the people, for whom people won't even watch the movie if the movie is given, given freely to them. If they are given tickets free for them, the people will not even spend this time. So definitely if people are watching this movie, they are watching for the Salman Khan. So definitely the profit will go to him. And there are two reasons. First, it is not enforceable, even though there are acts with respect to the minimum wages or with respect to the equal salary, but still they cannot claim it because I'm a private individual. My whole focus, my whole business is dependent on what? It is dependent on profit. So I will definitely pay more to whose movie is watched by people rather than to those whose movie is not watched by anyone. And here I would like to discuss nepotism in cinemas. This case often discussed, and it is, there are many actors who cry over it, why there is nepotism in cinemas and why they are given chances, all that. I will try to explain it here, because right now we are discussing the directive principles. We are discussing article 38, that the state should endeavor to minimize the wage differences. We are discussing this, but as we are discussing right now, it may be very much useful for your interview if you reach to that level where your personality would be checked. This statement, this discussion may be very much useful for you. So what is the discussion? Suppose Shah Rukh Khan, he has a daughter. I don't know what her name is, and he has a son. Aryan Khan, because of his controversy with respect to drugs. I know his son, not her daughter, not his daughter. Now, there is some other actor, maybe anyone, who is often crying about the nepotism. Maybe I don't know much Bollywood. Maybe some actor who are crying about the nepotism, and they want to get the lead role. They also want to get the lead role. They also want to get the lead role, and I am the producer. Whom I will prefer? Definitely, I am a private person. My whole business runs on the profit. It is all about the profit. I will choose them over this person. Why? Because if I have a Shah Rukh Khan's daughter, or if I have Ananya Pandya, I have somebody else. Even though they had come to the industry because of the nepotism, but this industry, it is a private industry. I am a private person. I am making this film. I would want them to work for me so that they will attract the people. They will attract the people rather than whether they know acting or not. They will attract the people. They will generate more views rather than this person. He might be better actor. He might be, he might be much deserving, but he is not known to the people. If he will earn this respect, if he will earn this by hard work, then only I can, give opportunity to him. Rather than, why would I give opportunity to some person on which the business, my business would be under threat? Definitely I will choose this person. So this whole business runs on the profit, and I don't know why people are, why they are crying over it. They have to develop their brand, develop your brand so big that everybody would want to hire you. So this is what they should do, and this is what it happens. Similarly, for example, we have cricket teams. We have men's cricket team and women's cricket team. Men are paid very high, and women's cricket team, they are not paid that much. Can they go to the court? Sir, BCCI is doing this, they are discriminating between us. Court will tell you, first of all, we had given you the judgment when we discussed the fundamental rights. There the BCCI is not the state. Second thing, even if it would have been the state, but it is first, it is not a state. Second thing, it is not enforceable. Directive principles are not enforceable. Even though we had enacted a law now, it is not a state. The business of BCCI, it also depends on the generation of revenue. And the men's cricket team, they generate much revenue as compared to the women's cricket team. That's why they are getting paid more than you are getting paid. So this is the simple logic which people often misunderstand with respect to the private industry. So that is the reason. So here, what does the Article 38 say? Article 38 says that the state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status and opportunities, not only amongst individuals but also amongst groups of people residing in different areas or engaged in different vocations. And also in how they can reduce the inequalities in income. How this can be reduced inequality in income? By the distribution of wealth. If we look at our country, the status of our country right now, almost 90% of wealth is confined in 1% of the population's hand, and the rest 10% wealth is confined with other people. So this much inequality is in our country. Even though we are the growing GDP, but still the inequality is very harsh. That the GDP in itself reflects the wrong information, as it is one of the criticism to the GDP. So what state shall do? State shall try to minimize this inequality of income. So this is what Article 38 says. Now Article 39, this from here now the discussion starts. What does the Article 39 say? Article 39A, then we have Article 39A, Article 39 and Article 39A. I guess I had not included Article 39B in it. Article 39B and Article 39C, I had not included it. Well, that is not the case. Well, what does the Article 39 say? Article 39 says that certain principles of policy to be followed by the state. The state shall in particular direct its policy towards securing that all the citizens, men, women equally, have the right to an adequate means of livelihood. For example, we had brought the Manrega, at least they should be earning something. We had, what I told, it is a to-do list for the government. These DPSPs are the to-do list for the government. Then that the ownership and the control of the material resources of the community are so distributed as best to subserve the common good. They had abolished the zamindari system. Then that the operation of the economic system does not result in the concentration of the wealth and means of the production to the common determinant. If they have if there was the zamindari system was still there, then it will lead to the concentration of wealth, and state shall endeavor to do it. Then D, there is equal pay for equal work for both men and women. This is what we had achieved, that for the same work, that the health and the strength of workers, men and women, and the tender age of the children are not abused, and that citizens are not forced to by economical necessity to enter avocations unsuited to their age or strength. We had discussed it in the fundamental rights, how the working age limit was reduced for children, and after 2016 amendment how it was done. Then if the children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and the childhood and youth are protected against exploitation and against moral and material abandonment. We have POSCA Act. We had, in a nutshell, the purpose of this the directive principle is that what we do, the purpose is that we should try to do it, we should try to achieve it, but still there are few fundamental duties which we have not achieved yet. Now let's have a look at it, article. Now let's try to compare. These are fundamental rights. Now let's try to compare it. We have, as we saw in article 39 B and C, that ownership and the control of the material resources of the community are so distributed as best to serve the common good. So it was in contradiction with articles. How? Let's try to discuss that. Let's try to discuss it. We had article 31. What does article 31 say? That you have the right to property. First, what essence we can get from article 31? You have right to property, which is a fundamental right, and state cannot take your land unnecessarily if it is not for the public good. So for the public good, your land can be taken, but state will give you the compensation. This is article 31. Then we have article 39b and article 39c. What does they say? Article 39b says ownership and control of the material resources of the community are so distributed as best to serve the common good. Then article 39c says the operation of the economic system does not result in the concentration of wealth and means of the common good. So let's see it, that the ownership of the control of the material resources of the community are so distributed as best to serve the common good, and C, that the operation of the economic system does not result in the concentration of wealth and means of the production of the common detriment. Now, as we discussed that it is the to-do list for the government. What they did, what government did, government decided to abolish the government. We have article 31 here. This is something which is very much interesting and very much important to understand. We have article 31 where we have the right to property. Government brought in the abolition of zamindari system, in which the land of the zamindars, it was distributed for the common good between the tenants, between the peasants, in a nutshell. Now the case went to the Supreme Court, and they questioned this action of the government. They questioned this action of the government, and they asked this to the government. Sir, how can they do this? How can the government do this? They are not giving us what they are not giving us. They are not even giving us the compensation for it. They are not replacing this land with some another land. They are acquiring our property. Can the government do? Can they do it? The court said that it is violation. It is in violation of the fundamental right. And what were the articles which were discussed? Article 14, which talks about the right to equality. Article 19 F, we had right to property, and Article 31, which talked about compensation. It was in violation of these articles. So it is unconstitutional, and court said yes, yes, this zamindari, you cannot abolish zamindari system because it is unconstitutional. So what did the parliament did after that? They did something interesting. Till now, let me repeat again. Article 31, it talked about the right to property. It talked about the compensation if the state will take your land. State will not just take it your land without thinking much. They will do one thing. What they will do, they will give the compensation for that, and that land which they are taking, it would be for the public good. They went to the court and they said to the court, sir, it is in violation of what they are doing under Article 39 B and C, 39B and 39C, which was used that the concentration of wealth is not allowed. They should not concentrate the wealth. Where here we discussed that Article 39B, that the ownership and the control of the material resources of the community are so distributed as best to subserve the common good. And the second, that the operation of the economic system does not result in the concentration of wealth and means of the production to the common detriment. So if we will see these two articles and we compare it with the Article 31, we were in a way, the government was in a way trying to give more value to these 39A and 39B and 30C. Government was doing what? They were giving more value to these three fundamental rights, and the court said that it is in violation of the constitution. It is something which you cannot do. So after that, government is government. They want to do, if they want to do anything, they will find out the ways to do it. What they brought the first Constitutional Amendment Act. What they brought first Constitutional Amendment Act. First Constitutional Amendment Act in 1951. And what was added in it? Article 30 was amended and Article 30A was added in the Constitution. What was the Article 30A? What does the Article 30A say? It says that when a state acquires any land, it shall not be deemed to violate the Article 14, 19 and 31, and we can take over management of any property for the public good. So Article 30A said, if a state acquires any land, it shall not be deemed as the violative of Article 15, Article 14, Article 19 and Article 31. It shall not be deemed as violative of Article 14, 19 and 31, and we can take over management of any property for public interest. It was inserted under Article 30A. And also Article 31A, also Article 31B was introduced. And what does it introduce? It introduced ninth schedule. And in this ninth schedule, what was the advantage? If any law is brought in the ninth schedule, it would prevail and there would be no judicial review to that law. So they brought up two things. First, Article 31A, which was added by the Constitutional Amendment Act. First Constitutional Amendment Act, they introduced Article 31A, which said that when a state acquires any land, it shall not be deemed to violate the Article 14, 19 and 31, and we can take over management of any property for the public interest. Then Article 31B was introduced, which introduced the ninth schedule, and any law which placed in the ninth schedule is free from the judicial review. But still, the question was different. The question was, right to property was still a fundamental right, and DPSPs are still not enforceable. And what the country is doing, what the government is doing, they are using these Article 39B and C. They are giving it more value than Article 14, 15, 14, 19 and Article 30, Article 31, 14, 19 and Article 31. They are, government was trying to give more power to it than those articles. So after that, what happened? Another case came to the court. First, related to the privy purses of the princely states, which they were promised to be given once they will join with the Indian Union and with the bank nationalization. These two changes were brought in. First the PV purse, then the bank nationalization. When the PV purse was abolished and the banks were nationalized, 14 banks were nationalized, the case again went to the court. Reason is abolition of PV purse. Why it was abolished? First, why it was given? It was given to the rulers of these independent states when India got independence, so that if they will join with India, they will have their places to live. उनको महल उन्हीं के पास रहेंगे. They will have all this stuff what they had. They will have their property, but they will have to lose their sovereignty and join with India. So first thing. Then the second thing, bank nationalization. Why it was abolition? Because Indira Gandhi thought that these banks, they are giving loans to their people and they are not giving loans to the poor people. So we need to nationalize the banks. And why they wanted to abolish the PV purse? Because these rajas, they would use this money in separating the campaign against the government, which they could not have highlighted in the amendment, but they eventually amended it. When they amended it, again the case went to the court, and court said that this is something called unconstitutional. Why? Because you cannot enforce DPSPs over fundamental rights. Fundamental rights are much superior than DPSPs. So this was established. But government is government. They will still work on it. They will still try to convince, they will still try to bring in what they believe in. So what they did, they brought the 24th Constitutional Amendment Act, in which they made it very much clear that president will have to give the assent to the bill. After this, they brought in they have to give the bill to the constitutional amendment bill. President has to give the assent to the constitutional amendment bill. President can't say no. President can't use the veto power, but he has to give the assent. Then they introduced this 25th Constitutional Amendment Act in 1971 itself. It was also in 1971. What the 25th Constitutional Amendment Act said, it brought few changes. What were the few changes? It brought Article 31C. What does the Article 31C said? If a parliament wants to enact a law and you want to give effect to two directive principles. For example, if a parliament, they want to enact a law, and in this law they want to give effect to two directive principles. What are those two directive principles? 39B and 39C. If they want to give effect to these two directive principles, it should be understood that it does not violate. What it does not violate? It should be understood that it does not violate Article 14, Article 19 and Article 31. It should be understood that these, if court, for example, under this 25th Constitutional Amendment Act 1971, the Parliament, they brought a Constitutional Amendment Act, which is 31C. Under 31C, what it says, if the Parliament wants to enact any law and they want to give the effect to the two fundamental rights. What are these two fundamental rights? It is 39B and 39C. If they want to give effect to these two fundamental rights, and it should be deemed that it is not violating these articles. What are these articles? Article 14, Article 19 and Article 31. Article 31. It should be deemed that it is not violating these three articles. So here the issue was sorted. In earlier we saw that how even after PV purse was abolished, even after the nationalization, even though we had the introduced Article 31A, we had introduced Article 31B. In Article 31, it was very much clear that violates Article 14. When a state acquires any land, it shall not be violate the Article 14, 19 and 31. It was not clear that the fundamental duties will supersede the fundamental rights here. The directive principles will supersede the fundamental rights here. But in this judgment, the court was very much clear that In this Amendment Act, 25th Constitutional Amendment Act 1971, the court was very much clear that the Parliament was very much clear that these articles 39B and 39C, which are the fundamental, which are the DPSPs, they may supersede these articles, Article 14, Article 15, and Article 31. So here we established two things. Here we established one thing, two things. First, fundamental rights are superior than DPSPs. But if you have, but there are two DPSPs, which is Article 39, 39B and 39C. They are superior than what? They are superior than few fundamental rights. What are these fundamental rights? 15, 19, and 31. They are superior than these two fundamental rights. This Article 31C, it was again challenged in the court. It was challenged in the Keshwananda Bharati case, and what Supreme Court did for the Article 31C, which was introduced by the 25th Constitutional Amendment Act, it was challenged in the court in 1973 under the Keshwananda Bharati case, and it said that it accepted that it is very much in line with the Constitution. But one more thing, it was very much described that this law, if any made, it should, earlier it was under Article, it was said that the laws which are made, after the 25th Constitutional Amendment Act, if any law would be made which is violative of Article 31A and 31, Article 31, which is violative of Article 14, 19, and 31, when giving effect to the Article 39 and 39B and 39C, it is not, there is no judicial review. But the in the Keshwananda Bharati case, it was very much highlighted that even though it is not, it is constitutional, but judicial review will always remain there. So this is what we established so far with the relationship between fundamental rights and the DPSPs. Let me rub it first here, then we will move forward. So in the Keshwananda, first what we established till now, the relationship between fundamental rights. Fundamental rights are always superior most of the times with respect to DPSPs. But Article 39B and Article 39C, when state makes any law to give empowerment to enforce these articles, then these two articles will supersede with respect to the fundamental rights. Which are those fundamental rights? Article 14, Article 19, and Article 31. So it will supersede these articles. And here the question of the judicial review, it was described by the Keshwananda Bharati case. So till now it is clear. Then came the 42nd Constitutional Amendment Act in 1976. So as we know that 42nd Constitutional Amendment Act, it is highly, criticized, because it was brought in to cover up the I'm not remembering the word. I have this problem. So whatever it was to cover up the actions of the government. The emergency imposed by the government. It was to cover up this. It was to make it all legal. And about 42nd Constitutional Amendment Act, it is said that it is a mini constitution. Also, it is said that it is also a mini constitution or mini revision of the constitution. This type of question may be asked: which of the articles is considered the mini constitution or mini revision of the constitution? It is 42nd Constitutional Amendment Act. So in this 42nd Constitutional Amendment Act, a new provision was introduced, which is that if Parliament wants to enact the law and wants to enact one or more DPSPs. Here, if a parliament wants to enact a law and give and to enforce one or more DPSPs, to enforce one or more DPSPs, and in this enforcement they are violating Article 14, Article 19, and Article 31, and in this enforcement they are violating these Article 14, 19, and 31. Then what will happen? It can't be made, this law can't be made unconstitutional. It was big provision, it was such a provision. Because of this, we could have done anything. It was highly controversial, because in nutshell what it is saying, that you can, to enforce any fundamental, to enforce any DPSP, if you want to enforce it, you can enforce it easily. And once you enforce that, it won't be said that it is violative of Article 14, Article 19, and Article 31. Earlier, what used to be? Earlier, it used to be only 39B and 39C. Now, what is? Every DPSP, whatever DPSP it is, if you want to enforce that, if you want to enact a law for that, that would supersede these articles. It was in nutshell. But, the case went to the court again in the famous Minerva Mills judgment 1980. In the famous Minerva Mills judgment 1980, till now in 1980, Article 31, it was taken away from the fundamental rights, because there were various amendments going on, so the status of property was taken away. Now we only had Article 14, Article 19 versus DPSPs. So under this Minerva Mills judgment, the Supreme Court brought the balance, judicial, Supreme Court brought the balance, which was the harmonization, the harmonious balance, the harmonious balance was brought in. It was established, and it was established that this harmonious balance between the fundamental rights and the DPSPs, it is a basic structure. It can't be amended, it can't be changed. This has to always looked after. And second thing which was established, that judicial review is also a basic structure. And it was reversed again, that if the earlier position was restored. What was the earlier position? If parliament has to enact any law to give power to these articles, they can supersede Article 14, 19, and 31. Now 31 is not there, Article 14 and 19. So this is what finally was agreed to. So this is what article, this is the relationship between the fundamental rights and the DPSPs. Now again in 2024 there was a judgment with respect to the common good, whether in this judgment all the property would be considered. For that, it was a 9-judge bench. The decision was taken that it is not whole the property would be taken. Under this judgment, the draw, it in a way criticized the 9-judge bench, which the case was actually about the Property Owners Association versus the state of Maharashtra. Sorry, I will first rub it here. Now let me cut it short. What we achieve right now, what we follow right now in the 2024 judgment. What was the case? It was the Property Owners Association versus the state of Maharashtra. The case, you don't need to go to the depth of the case, but what I will tell you, the few points. There was there used to be these property owners. They will give their land to they will give their property to the tenants who will live there. And by the time in the Bombay, the conditions would often change because of the continuous rain, environmental conditions. The property would deteriorate, and it was not suitable for the living. So the state interfered, and they took their property and gave it to the gave it to the cooperative, and they approached the court, and finally the judgment came in where it was said that if you are using article 39b and article 39c, for that if you are making any law or you are doing such actions, you are not allowed to take whole property. Full property you cannot take. You cannot take it totally and give it to the cooperative for the public good. You can take part of it, and also in a separate law, it has been established that if the state will take your land or your property, they will have to give the compensation, and it was introduced in 2013. So this is right now what we follow with respect to it. So this is the relationship between the fundamental rights and the directive principles. What it is, now let me recap it again for you guys. Often fundamental rights are enforceable and they are superior than directive principles. But there are two directive principles, which is 39b and c. They are superior to what? Article 14, article 19, and it was superior to 30. Now 30 is not there, 31 is not there, so they are superior to article 14 and 19 if the government wants to bring in any law. But with respect to that, they cannot take your full property, and also they will have to give the compensation. So this is what article 39 is about, and I hope till now you had understood the comparison between the fundamental rights and fundamental duties also. Now let us move forward and read the articles. Now there is nothing left in the DPSPs, just we have to read them to have the understanding what article 39 says, that the citizens, men and women, equally have the right to adequate means of livelihood. We are trying to achieve it, that the owners and the control of the material resources of the community are so distributed as best to serve the common good. We discussed it in a very detailed manner, that the operation of the economic system does not result in the concentration of wealth and means of the production to the common detriment. We established it also, that there is equal pay for equal work for both men and women. We discussed that too, that the health and the strength of workers, men and women, and tender age of the children are not abused. That is true, and that the children are given opportunities and facilities to develop in a healthy manner and in a condition of freedom and dignity, and the childhood and youth are protected against exploitation and against moral materials. That's what we are enduring to do it, and we had brought various laws with respect to that. Similarly, article 39a, equal justice and free legal aid, that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity, and shall in particular provide free legal aid by suitable legislations or schemes in any other way to ensure that the opportunities of securing justice are not denied to any citizen by reason of economic or other disability. This is also true. It is also which we had achieved. That is why I said, the Nehru said that it will act as the government's to-do list. We had done something in every article. Similarly, we have Article 40, Organization of Village Panchayats. We had brought it by the 72nd Constitutional Amendment Act. That article, the state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as the units of self-government. Definitely, it is the Gandhian principle. Right to work, to education, and to public assistance in certain cases. The state shall, within the limits of its economic capacity and development, make effective provisions for the securing the right to work, to education, to public assistance in case of employment, old age, sickness, and disablement, and other cases of undeserved want. Definitely, it is also a also a Gandhian as well as socialistic principle here. Provisions for just and human conditions of work and maternity leave relief. It is we had also brought the maternity leave where the woman is given the paid leave for the 24 weeks. We had achieved it also, and it is the socialistic principle. Whenever you see work, mark it socialistic principle. Then Article 43, living wage, etc. for workers, also socialistic principle. The state shall endeavor to secure by suitable legislations or economic organizations or in any other way to all workers, agricultural, industry, or otherwise work in living wage conditions of work, ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities. And in particular, the state shall endeavor to promote cottage industry on an individual or cooperative basis in rural areas. This may also be Gandhian principle, because we see the cottage industry, it is much related to cooperative basis, it is much related to Gandhian principle. Then we have Article 43, participation of workers in management of industries, This is the socialistic. Then the promotion of cooperative societies, this is the Gandhian. Then we have the Article 44 Uniform Civil Code, which we will discuss in a very detail. After just we will go through these articles, what they are about. Then now we have to discuss the Article Uniform Civil Code in detail, and then fundamental rights are done and dusted. Now Article 45, sorry, DPSPs are done. Article 45 provisions for early childhood care and education to children below the age of 6 years. We had discussed it, and we had amended the constitution and brought Article 21A as the fundamental right. Then we have Article 46, promotion of education and economic interests of scheduled castes, scheduled tribes and other weaker sections. We had amended constitution and brought Article 15, clause 4, where we had given advantage to them. We saw that this Doirajan case, it was also challenged in the court, and court made under what Maharashtra government has done, gave reservation to these people. What court did? Court said that it is violative of the fundamental rights to give reservation, because you are going for inequality. Then the Maharashtra government said that we have this Article 46 which endorses us that we should establish it. Then the court there said that fundamental rights are superior than the DPSPs. But further the constitution was amended and Article 15(4) was introduced. Then Article 47, duty of the state to raise the level of nutrition and standards of living and to improve public health. 100% government has done every step to achieve it. We have brought meals for the children. We have healthcare, free healthcare system, primary healthcare system in our villages. Then the 48th organization of agriculture and animal husbandry. That is also true. We had various schemes running in the villages that they are giving the subsidies for the animal husbandry. Then we have the protection and improvement of environment and safeguarding of forests and wildlife. We have environmental laws with respect to that. We had done it. Then we have 49, protection of monuments and places and objects of national importance. We had the monuments, laws related to monuments, ancient monuments we are protecting them. Then we have separation of judiciary from executive. This we had already achieved. This is Article 50. Article 51, promotion of internal peace and security. The state shall endeavor to promote internal peace and security, maintain just and honorable relations between nations, foster respect for international law and treaty obligations in dealing of organized peoples with one another, and encouraging settlement of international disputes by arbitration. Now, this is very simple to understand. This is something which you can read easily. There is nothing big which we cannot understand. The reason I brought it, I would have not even consulted these articles, but the necessity was we had promised you that we will cover everything. So that's why we brought it. We read it here for you guys. Now the question is about the Uniform Civil Code, which would be the last discussion of today's class, and then we'll finish it. After that we'll take our class tomorrow and discuss the fundamental duties. So what does the Article 44 of the Constitution say? Article 44 of the Indian Constitution, what does it say? Let's have a look at it. Here it would be, no, here it is. Article 44 says, the state shall endeavor to secure for the citizens a common civil code throughout the territory. The common, a uniform civil code, not a common, a uniform. I made a big mistake. If it was a common, then that whole discussion would have been different. What does it say? That the state shall endeavor to secure the citizens a uniform civil code throughout the territory of India. Uniform civil code throughout the territory of India. If we talk about the criminal laws, now I will ask you a question. If you are watching this video, suppose if a Muslim murders someone, what would be his punishment? If a Christian murders, what would be his punishment? And if a Hindu murders, what would be his punishment? The punishment would be same, because we have a common criminal code. The judges will look at the severity of the crime, and after that they will decide from case to case. For example, we saw that the rarest of rare principle, where in one case when that person raped his daughter and then killed him and his mother also, it was highlighted by the courts that it is not a rarest of rare case, and he was only given life imprisonment. But same judge, when they were hearing the case of a child, a 7-year child who was murdered, for the same judge, it was the rarest of rare case, and the person was given the death penalty. So it will differ. Depending upon the case, it will differ, but the punishment would remain same. This is the criminal justice system. This is the uniform criminal code in our country. Now, what about the civil code? What about uniform civil code? Do we follow uniform civil code? Do we have uniform civil code in our country? The question is about whether do we have uniform civil code or not. If we will see the civil laws in our country, for example, with respect to if there is a dispute over property between two individuals, there would be, then we have the civil code, we have the uniform civil laws too. But in the civil laws, there is another term which is called the personal laws, and these personal laws deal with variety of things. First, they will deal with marriage, they will deal with divorce, they will deal with inheritance, they will deal with what? They will deal with adoption. So let's take an example of marriage. How marriage is done in the Muslim community? For a Muslim community, a marriage would be valid. A marriage is valid until both parties, man and woman, they agree three times, that they agree to this marriage three times. They say kabul hai, kabul hai, kabul hai. Man and woman, they say it three times, then they will be married. So their marriage law is different. And once they are married, they will have children. The inheritance law is different. The man will get extra than the girl child. Then what about if for suppose now, let's assume that they are not able to conceive and they want to adopt a child. What about his inheritance? Will he get the inheritance? The answer is no. So the inheritance law is different according to under the Islamic law. What about divorce? Can a woman approach to the court and say, can a woman divorce his husband if she is a Muslim? No, she can't divorce his husband, because this divorce, the power to divorce the woman, power to go for the divorce, it is kept with men. What is the reason? Because men pays the dowry. First, dowry is paid by men. Second, man takes care of the everything about the family. If woman has the money, that is woman's money. Man cannot even touch that money. Because of these reasons, this power is with the man. Now, this is the code followed about divorce. Can a woman take divorce? No. What about Hindu woman? If there is a Hindu woman, what about her? What about a Muslim woman? If there is a divorce now, what about what about her maintenance? A man has to pay only for 3 months. Muslim man has to pay the maintenance to the woman. After that, he is not supposed to pay the maintenance. But what about Hindu woman? If she will get the divorce, she will be paid maintenance for her entire life. So these are the things. These are contradictory in our society. But one thing is very much clear, that we as India is a diverse country. Here we have the there is minorities with respect to culture. We saw that how in a culture there is a custom that if you want to marry a woman, just kidnap her. By the permission of her parents, you are married. If you want to divorce, just cut the leaf. So we have the diverse culture, we have the diversity in the religion, we have the diversity of the races. We are so diverse. Definitely, there would be the diversity with respect to their laws, because we respect that. We have Article 25 where we respect your personal laws, where we respect your religious freedom. And religion, if we will understand, religion gives you rules and religion gives you do's and do nots. So these are followed, they become the rules, and these things happen by the rules. Now, what is the motto of the Uniform Civil Code? The motto of the Uniform Civil Code is that there should be a common, if we believe in secular nation, there should be a uniform law. There should be a uniform law which will govern all these people in a, which will govern, which will encircle all these people in a single unit, so that we believe in fraternity, the common brotherhood. If this uniform civil code is, it will lead to common brotherhood, it will lead to the secular nature of the country, and it would be good for the country. But is this argument valid or not? That is something different, which we will discuss in a little while. But here the major purpose is, we can the diversity in our country, it can be added, it can be encircled in a single unit, so that there would be a common law which will govern them. The inequalities which different people believe in religions are, for example, here a Muslim woman, they, for a Muslim man, he has to only give the alimony for the 3 months, but for a Hindu they have to give alimony for whole life. So these inequalities, they can be curbed, there would be absolute equality in the society. So this is the major reason why this uniform civil code is there. But the question is, if it is the reason, if this was the reason, why did not the makers of the constitution brought this uniform civil code? Why it was not given the fundamental rights status? Why it was put under the part 4 of the Indian constitution, which is not even enforceable by the law in the court? Why it was put there? So the reason for that is very much simple. After independence, our country was divided on the basis of religion, and we were inviting different states, different princely states, that please be the part of Indian Union, and we will give you all these rights. We will protect you. We will protect your property. We will protect. We were inviting everybody. We were trying to convince Muslim that don't go to Pakistan. That is a lie for you. Here we have the country. We belong together. We live together. Our ancestors are buried together. Why not you stay here? So they tried to convince, and if at that time they would have brought the uniform civil code, the Muslims would have feared. They would have feared what will happen to their religion. If the uniform civil code would be brought in, what will happen to their religion? Their religion would be under threat. They would not even be let to practice their religion. If they would have to divorce, they will have to go to the court, and the court will divorce for them. If a woman would want to divorce, they will go to the judge, then the judge will divorce for her, and according to Islamic law, that divorce is not valid. So there are various issues related to it, and it would have threatened the unity in the country. So because of that, it was kept in the DPSPs, it was kept in the directive principles. When the consensus will be made between the societies and the government, between the people and the government, then government can go for the uniform civil code. So with respect to this, I had an example in my mind. You would have heard about Shah Banu case. She was a 60-year-old woman, I guess, and she was married to a lawyer, and this lawyer man, he fell in love with a younger woman, and he divorced her. Once he divorced this 60-year-old woman, and according to Islamic law, there is a rule that you have to pay, as I mentioned here, that you have to pay the alimony, the maintenance, only for 3 months. Only for 3 months you have to pay the maintenance. This Shah Banu, she approached court. She approached the court, the Madhya Pradesh High Court. She approached and said, "Sir, there is violation of Article 15. There is violation of Article 14. Equality is under threat." The court said, "Why?" She said, "Look at the Hindus. Look at their women. When they get divorced, they get alimony for whole life. But when I get divorced, I get alimony for only 3 months. There is definitely violation of inequality, violation of equality." So the Madras High Court, they agreed with her, and they said that she will get the maintenance for her life. This case went to the Supreme Court. The Supreme Court agreed with the Maharashtra court, and it was established that the Muslim woman will get the alimony for whole life. But then what happened? It in a way, it is, even though it may seem good for money, it may seem bad. We have the difference of opinion. According to me, if I am earning my money, I am working hard, I am doing everything to feed my family, and tomorrow if my wife would decide, we will split, then I should not be forced to give my money to her. So I believe that it is good that I will pay her for certain time, then after that time I will not pay her, because it is my hard earned money. But for you it might not be that good, because you will think in a different perspective that she is a woman, where she will go, he divorced her, he cheated her. But these are different cases. The point is, there were Muslim men who got irritated by it, and they went to the Rajiv Gandhi and told him, do you want to win the election or not? If you want to win the election, then do one thing, bring a law which will supersede this judgment of the Supreme Court, and which will protect our rights. And what they did, the Rajiv Gandhi in 1986, they brought the Muslim woman protection of rights and Divorce Act 1981. And under this act, it was made mandatory that this would be given only 3 months. But still, the maintenance would be given only 3 months. But still, the government was under huge crisis. The government was under huge crisis, and there were lots of people saying that the government is trying to appease the minorities. So what Rajiv Gandhi did, he opened the doors for Hindus to Ram temple. So he tried to win both parties here. But still, this system, it was challenged in the court. And when it was challenged in the court, it was finally decided by the court that let's balance the both. Let's balance the religious law with the right to equality. How it was balanced? That there would be 3-month alimony only maintenance, but we will fix the maintenance in such a way that this money which she will get, that would be enough for her lifetime. So this was finally established. In a way, the point is the uniform civil code. If we had the uniform civil code, this issue would have never come. But can we afford the uniform civil code? Looking at the diversity of the country, looking at the Article 25, where you can easily propagate your religion. We have Article 29, where the minorities are, linguistic minority and religious minorities, they are, cultural minorities, they are protected. So can we afford the uniform civil code? That is the real question. Now, let us see what are the arguments in favor of the uniform civil code and what are the arguments which are against uniform civil code. Let's discuss them one by one. First, we will discuss arguments in favor of. First, it will to uphold the constitution, because constitution says that there should be the uniform civil code. So it is good to uphold the constitution if we will bring in the uniform civil code. Second, to uphold the secularism. But there is a question. What is India's secularism? We discussed that our view of secularism is different than the Western view. In the France, if you are following any religion, have that religion in your private home. When you are in public, don't show it to the world what you believe in. For Australia, what your religion is, that is great. Follow it, we are not going to interfere. For USA, we are not going to interfere. You have your own religion, there is absolute freedom. Believe whatever you want to believe in, but don't do those actions which will impact the security of the state. For India, our view of secularism is different. Our Indian state does not have a secular nature. Our Indian state does not have any religion. We have a secular state. We don't abide by any religion. But at the same time, we respect everybody's religion. We give rights to everybody's religion. We don't discriminate on the basis of religion, but at the same time we interfere little bit. But still, we don't discriminate. We have Article 25, which lets you do whatever you want to do. If you have religious laws, follow those religious laws, unless and until it does not violate the fundamental rights. Unless and until, if you are following a religious law, which is not a essential feature of your religion, and it is violating the fundamental rights, then only we can struck it down. But you can follow your religion. So bringing uniform civil code, it will bring in the secularism, definitely. But which type of secularism which will bring in? It is going to lead towards the secularism of the France, because if we will have a common law which will not belong, if we will have a uniform law which will not belong to any religion, definitely we are in a way restricting their belief system. Definitely we are restricting the religious religious attachment for those people. So definitely it is going to the secular nature of our country is going to change. So here, for the argument's sake, we can say that it will uphold the secularism, that is true, which is the part of the basic structure of the constitution. Third, to end the allegations of minority appeasement, it will also end the allegations of minority appeasement, because we are bringing in different laws for the different minorities. They have different laws they follow, and they may be discriminating in nature, but they are there. And also the fourth argument, which is in favor, to give the gender justice. If we will understand one thing by reading, if we will try to understand one thing, the woman, there is injustice done by the people of the religion across all the religions. There is injustice done by the people of religion across all the religions towards the woman gender. So definitely, if we will have the uniform civil code, we can abolish all these things. Then what are the arguments which are against it? Let's have a look at the arguments which are against it, which are against the uniform civil code. Arguments against it. First, if you look at it, it says the state shall endure. It is not saying that state shall do it. Endure, here is the look at the language. Look at the language. Here, if we look at the language of the DPSPs, for all other acts, we have different, state shall do it, state shall do it. But for the uniform civil code, it is said that state shall endure. If state has to endure, what does endure mean? They have to consult the aggrieved parties. So definitely don't impose it, because we have the diversity. Consult them. If they are agreeing to it, then only bring in. And then the second point, which is raised here, that we already have a uniform civil code does not mean that Hindus, Muslims, Sikhs, Buddhists, Christians, they have a common code. What does uniform civil code mean? For example, there are Hindus have different parties. They have the Brahmins, there are Dalits, there are Lingayites, there are different. They should have a uniform code. They should have a uniform law. For Muslims, if they are Shia or Sunni, whatever they are, they should have a uniform law. For Jains, what they are, they should have a uniform law. So this is what uniform civil code means according to certain people, which is Faizan Mustafa. Then also the diversity, and also look at, we are seeing that, let's take again example of what? Maintenance in Islam. We are giving the Muslims are giving maintenance for 3 months, and we are taking, now many people can argue with it, but let's take an example of Atul Subhash case. Why did he did suicide? Because all his money, what he earned, went to that woman. So definitely, it is something which is to be discussed upon. And then fourth point, if you are going to bring in the uniform civil code, what would be the model of the code? On what basis you will bring in? Will it be based on the Islamic Sharia law? Would it be based on the Hindu law? Would it be based on the Christian law? On what basis you are going to bring in? If you are going to bring in, it will become like a common code rather than a civil code. So similarly, with respect to this, the Law Commission said that, in nutshell, there is no need to bring in the uniform civil code. Neither there is a necessity nor it is desirable to bring in the uniform civil code. But still, if we look at our states, there are 2 states which had brought the uniform civil code. And what are these 2 states? It is the Goa, and it is Uttarakhand in 2024. Let's discuss the case of the Goa first. They have uniform civil code. What was the reason? Because they were the part of the Portuguese, and they got in they we added you know uh, it was a Portuguese colony, and we added it later with Indian Union. So they already had this idea of the uniform civil code, the model code of conduct there, and it is very beautiful there. There the laws are very beautiful, but if we look at those laws, if we analyze those laws, they are also discriminating, but they are uniformly discriminating. For example, let us discuss. Let's discuss how it is discriminatory. For example, what is the procedure of marriage if you want to get married in a Goa? Procedure of marriage. What is the procedure of marriage? There would be two signs which you will have to give. First, when you would decide, and second, when the marriage would be solemnized. So these two signs are there. But what about the Catholics? They have different. They have a different. They have a little different. It seems that there is an understanding between the Catholics and the Goa's civil code. What is that? The first signature is necessary for them also, but if the marriage is in church, then there is no need for the second sign. Definitely there is discrimination against the another religions. Similarly, with respect to divorce, there is discrimination. It is common to all religions uniformly, but for Catholic there is discrimination. You can add conditions. Non-consumption of marriage. If the marriage is not consumed, if both signs are, you have to given the both signs, but second signature was in the church, and you had not consumed the marriage, then then you can dilute this marriage. You had not had a sexual relationship, then you can dilute it without any delay. You can divorce even after the even after the non-consumption of the marriage. Then similarly, with respect to assets, what are the assets? There are different issues with respect to it. For example, the property of a boy and a girl, whatever they own, it will be separate. They will have a separate property, but once they get married, their whatever property they will acquire after marriage, that will have it would be a common property. But here also there is a gender bias, that man will be the manager of this property. So definitely there are various issues with the Goa's uniform civil code. So what is the alternative to this uniform civil code? What can be the alternative? The alternative is the Special Marriage Act. What is the alternative? It is Special Marriage Act. Earlier, if you want to marry a Muslim man, or you want to marry a Hindu man, and you belong to different religions, the understanding which is there, that you cannot just marry. You have to first convert, then you can marry. If you are a Hindu and you want to marry a Muslim, you have to first convert to Islam, then you can marry a Muslim man. Similarly, it would be for the Hinduism. But for the Christianity and Islam, there is a little understanding that if a woman is Christian, she can marry a Muslim man and remain Christian. But that is the exception given to the Christians. But here, with respect to Hindus and Muslims, if you want to marry, then you have to convert. So to stop this conversion, it was in a way a forced conversion. To stop it, how can we stop it? If we have this special. Now, there is an issue. If you want to marry Hindu or Muslim or Christian, you have to convert. So to stop this conversion, what is the way? The way is the Special Marriage Act, that you can marry any person, but for that you do need to change your religion. But there are also issues with it. First, in the Special Marriage Act, the notice period. If you want to get married to any girl or any man from belonging to other religion, you would go to the you will go under Special Marriage Act. You would be told that first notice period would be given. and after 30 days, the date and time and location would be known, then you can marry there. So it has a benefit also. Why notice period? Maybe the person is duking him, maybe the man is duking the girl, the man is already married, so to protect her. But there is also an issue. Suppose they belong to two different religions and they want to marry, and the society does not allow them. So if this notice period and date and time is given, then what will happen? It will in a way violate their privacy, and the community from where they came, the people from where they came, they will come in and they will try to stop the marriage by force. So this is all one of the drawback associated with it. And another drawback is that you can marry in only that region. Either of the partners should belong to that region. If, for example, if you are from Delhi and you want to elope with a girl to the Karnataka and you want to marry her there, you cannot do it, because one of the partners should be belonging to Karnataka. But now what can they do? They will send the notice to them, and under this notice they will tell them these particular people they want to do the unthinkable, they want to marry. So if there is any objection to the people there, or if the man is already married or not, this will be seen, and this notification will be known to the people or to the families, and they may come in and they may try to stop the marriage. So this is also one of the drawbacks associated with it. So this is another drawback. And also, if a Hindu, third drawback associated with, if a Hindu marries a non-Hindu person, he will be not, he will, his property, he will be, he is not valid for the inheritance. He is not valid for the inheritance. He will not be in line for the inheritance. This right to inheritance would be taken away from him if a Hindu is marrying non-Hindu. And this is very specific to Hindus only, not to Muslims, not to Christians. So because of these three things which are in the Special Marriage Act, it is highly criticized. So this is the issue with it. Now, recently we saw that Uttarakhand government, they also brought the Uniform Civil Code. And let's have a look at the features of the Uniform Civil Code in Uttarakhand, and then we will finish our discussion. Uttarakhand Uniform Civil Code. In 2024 they brought it. There is a BJP government, and the focus of BJP, one of the major aim of the BJP government was bring in Uniform Civil Code. And also about now Uniform Civil Code, these are the personal laws related to marriage, divorce, adoption, inheritance. Can a state make law about it? Yes, exactly, because it is under the concurrent list. So state can make, and it is very much constitutional. So what does the Uniform Civil Code of Uttarakhand say? It has certain important provisions in it. So what are when they passed the Uniform Civil Code law with respect to the Uttarakhand, it was in violation of Article 25. But we know that if any law is or it was in violation of the Special Marriage Act, when they have to bring in such laws, it should, which are in violation of in the concurrent list. We have already Marriage Act, Special Marriage Act. We had these laws, so it was violation as these are in the concurrent list. These are by violation with the central laws. So for that to come into the existence, they have to take the presidential approval, and the president gave the approval, then only it was adopted. Now, what are the key features of it? This Uniform Civil Code, it only applies to the residents of Uttarakhand first. Second, it protects the rights of the STs. It protects their rights, so it does not apply to the STs. And also it has acknowledged live-in relationship. But if two persons, if a couple wants to be in live-in relationship, they have to register within 1 month. They have to register within 1 month. If they fail to do so, what they will what can be done to them? They can go to jail. They may be sent to the jail, or 10,000 rupees fine. This would be the punishment for those people who are in the live-in relationship in Uttarakhand and they had not, registered it. So also about the live-in relationship, if they conceive a child, suppose they conceive a child, will this child be legitimate? Will he be legitimate? With respect to the inheritance, would he be in line? 100% yes. He is acknowledged. There is no illegitimate child. It is the very much legitimate child. So these are few changes which had been brought in the Uniform Civil Code. It discussed the live-in relationship in a detail. It discussed about the about the illegitimate childs. They were not given the inheritance. Now they are given. Now there is a concept of void marriage. If a child is born of a void marriage, is that child legitimate? 100% legitimate, and he will be given the inheritance. So what is this void marriage? For example, if a girl, she was 16 years old and a boy 20 years old, they married, they had a child, and when she got the puberty, when she became 18 years old, 21 years old, and he became when she became 18 years old and boy became 21 years old, they decided to end this relationship because they wanted to make it void. Within 2 years they can, after attaining the legal age, within 2 years they can do it. Once this is ended, this marriage becomes void. So if they had any child, that child would be considered the legitimate child. So this is about it. And also about the polygamy. If you are in Uttarakhand, you are not allowed to go for the polygamy. Neither a man can have more than one wife, neither a wife can have more than one husband. So this is about it. So in nutshell, what is the objective of the DPSPs? The objective is to have the just law. The objective is to have a just law, to give objective is for the welfare of the people, and its objective is, it is fundamental in governance, but it is not justiciable. We discussed everything till now. I hope everything is very much clear. If there is any confusion, please do write in the comments. We will try to cover that. So with this, we complete today's discussion. Now let's have a look at the articles. What are the socialistic principles? Article 38 comes socialist, 39, 39A, 41, 42, 43, and 43A, 47. What are the Gandhian? 40, 43, 43B, 46, 47, and 48. And what are the liberal? 44, 45, 48, 49, 50, 51, 55, 50, 50, 51. So these are the articles which are divided in this way. So with this, we complete our today's discussion. I hope you would like the video. I hope you would share it with your friends. And I definitely hope you would subscribe the channel. Thank you for staying with me. Thank you very much and have a nice day.